Last month, the Seoul High Court delivered a landmark decision in the high-profile divorce case between SK Chairman Shea Tae-won and No So-young, director of Art Center Nabi. The court mandated that Chairman Shea pay 1.3808 trillion won in property division and 2 billion won in alimony. This verdict drastically increases the amounts from the initial ruling, which awarded 66.5 billion won for property division and 100 million won in alimony, setting a new record for the largest divorce settlement in South Korean history. In today's article, we'll examine the intricacies of South Korea's divorce legal system. Divorce. Divorce is the dissolution of a marital relationship through mutual consent or judicial proceedings. It is generally categorized into consensual divorce and judicial divorce. If a couple reaches an agreement on the terms of their divorce, such as parental rights, which encompass both social and legal custody until the child turns 20, and other custody arrangements, they can finalize the divorce without needing a trial. However, if the couple cannot agree on these matters, the case must be resolved through judicial proceedings. In South Korea, there are 6 officially recognized grounds for obtaining a judicial divorce. These include cases where a spouse has been unfaithful, when one spouse abandons the other with malicious intent, or if a spouse or their direct ancestors, such as parents, have experienced severe mistreatment from the other spouse. Additionally, divorce can be sought if a spouse's direct ancestors, like parents or grandparents, have suffered extreme mistreatment by the other spouse. Other grounds include situations where a spouse's whereabouts have been unknown for 3 years and other serious circumstances that make continuing the marriage impossible. The second ground of these involves a breach of the duty of support, which obliges spouses to ensure each other's essential needs for joint living, such as food, clothing, and shelter. The specifics of this support depend on the couple's social status and financial condition, but they must ensure each other their standard of living. The sixth ground pertains to cases where the marital relationship has irretrievably broken down, making it impossible to restore the essence of marriage and causing unbearable suffering for the spouse. The court assesses whether these conditions are met. Alimony and property division. When a couple divorces, issues of alimony and property division inevitably arise. Property division refers to the splitting of assets that the couple accumulated together during their marriage. In principle, this means that only the assets acquired or increased after the marriage are divided based on each spouse's contribution. However, even assets gained before the marriage may be subject to division if the other spouse's contribution to maintaining those assets during the marriage is recognized. On the other hand, alimony is compensation paid by the person responsible for the divorce to the other spouse. If both parties are at fault, neither may be required to pay alimony. Typically, alimony is determined to be between 10 million and 50 million won, regardless of the total assets owned. However, in the recent divorce case of SK Chairman Shea Tae-won, an exceptionally high amount of 2 billion won was awarded as alimony.